Case number 23S18766 FH People v. Milton Hensley Bay Jr. Defendant is present. He is in person. He is in chauffeur. Today's the Defendant for sentencing. And in front of him at the podium, I've provided 2 copies of his right to appellate.
All right. So, Mr. Hensley, we are back this morning for circuit court sentencing. He's appearing in person. We did try to start this earlier with him remote at the jail. It just made more sense for the court to have him present where we're not trying to talk through Zoom. So, Mr. Hensley, here we are again today, sir. First, I want to start with this. When I arraigned you a couple weeks ago, you were given the opportunity to request court-appointed counsel, and you were also given the opportunity for the last several months to retain your own counsel. Are you representing yourself today, sir?
For objection, for the record, make the record reflect. My appellation is Malik, title is Bay. Works American National, I'm the Islam.
Anything else?
Proper persona sui juris.
All right. So, sir, the information that I have in front of me has your listed name as Milton Joseph Hensley Jr. So we've been through this before. Respectfully, I'm going to call you by the name that is listed in the information, Mr. Hensley. So, Mr. Hensley, do you wish to proceed by representing yourself today, sir?
Over my Fifth Amendment right.
All right. You don't wish to answer any questions from the court?
Over my Fifth Amendment right.
All right. So you're not going to answer the court when I'm asking, do you wish to proceed representing yourself today for circuit court sentencing? You wish to do that, Mr. Hensley?
Objection. My appellation is Malik, title is Bay.
All right. So then let's get this on the record. As far as the PSI, Miss Bond.
This case wastes absolutely no time letting you know what kind of courtroom battle you're about to witness. From the very first seconds, we're dealing with a defendant who refuses to answer basic questions, challenges the court's authority, and insists on speaking in technical language that sounds legal, but doesn't actually move his case forward. The judge, on the other hand, has seen this play before. This isn't their first encounter, and that history matters. What you're about to watch isn't just a sentencing. It's a slow unraveling of a strategy built on obstruction, delay, and deflection.
Before reviewed it. And so after the review, that would have went out to all the parties sometime in March. So I also want the record to reflect, I've seen Mr. Hensley several times as it relates to sentencing. He had been appearing for all of his court appearances. He had been cooperating with the court as it relates to expressing his desire to represent himself in these proceedings. He's never wavered from that, which is why the court is inquiring again today. I recognize that sentencing is an important part of the circuit court process. It's certainly a hearing, if you will, that would require and entitle, I should say, the defendant to the assistance of an attorney, which is why I'm asking. However, the court is balancing that with the idea that this circuit court sentencing date has been delayed several times, and the court can't help but glean at this point it just appears to be a delay tactic. The court, we sift that back through the dates, has given Mr. Hensley several times to hire counsel. He expressed that interest. Again, it appears in hindsight that it's simply a delay tactic. The court has given Mr. Hensley several times, actually not even with the sentence that the court's required to give here in a moment, keeping him out on bond to do those things, explore counsel. Even after being arrested on the warrant when he failed to appear, the court also gave him the opportunity again to request court-appointed counsel. In fact, the public defender's office appeared at his arraignment. Mr. Hensley Bays had the ability to fill out the affidavit and request counsel. Here this morning, in response to the court's questioning, he does not appear interested in answering the court's questioning. Again, it appears to be a delay tactic. I am comfortable that the pre-sentence report has been provided months ago to Mr. Hensley. I am comfortable Mr. Hensley has been given ample opportunity either to retain counsel, to ask a court-appointed counsel, and therefore the court's going to proceed with sentencing today. I can't continue to allow this delay of the matter in what appears to simply be at this point, series of incidents and responses, or lack thereof of responses, simply to delay the matter. I know Mr. Hensley's been engaged with this. We have several filings that are not court filings that he has continued to send to the clerk's office, some of which he has referenced, none of which have anything to do with the case and or the court's requirement to get him sentenced now that he has been convicted several months ago of these crimes. So what I'm going to do is I'm going to start with then Mr. Butler. As it relates to the PSI, are you aware of any corrections, additions, or deletions that need to be made with it other than what we've already placed on the record with probation?
I would just ask the court to take a look at offense variable 4 regarding psychological injury to the victim. We did receive a victim impact statement. It looks like it came from Robert Siegel, who was the male occupant of the vehicle. In this case, the victim. We received that just this morning, about 2 hours ago. By email. So I could read that. I do believe it references facts to validate scoring for week 4.
All right. So why don't you read that? Okay.
This moment right here is critical, and it happens in a lot of cases like this. The judge is bending over backwards to make sure the defendant understands the risks of representing himself, not because the court is required to agree with him, but because the record must clearly show that the choice was informed. The defendant insists he understands the law, yet can't articulate how courtroom procedure, evidence rules, or sentencing guidelines actually work. That contradiction matters. Judges aren't impressed by buzzwords. They're focused on whether someone can meaningfully defend themselves.
It was insane. My daughter, who was only 9 years old at the time with special needs, was terrified, and it took months for her to feel comfortable riding in any vehicle again because she was scared someone was going to cut her life short for seemingly no reason at all. My wife had to start and is still in therapy over this whole situation, which has thankfully helped her anxiety levels to become manageable, but also is not covered under our insurance. So it's cost us quite a large sum of money, and that brings with it its own stresses to our family and social life. I find myself driving and cannot seem to relax because anyone I see speeding up behind us reminds me of the terrible people in the world and just how ignorant someone can be with disregard for others' lives, including those of its own family and child in the car. Being that there are previous charges against Mr. Hensley for almost the exact same situation where he brandishes a gun and threatens to kill people because of his unchecked aggression and inability to safely operate a vehicle, which then turns to road rage, I plead that the court recognize this man is a danger to society whose blatant disregard for human life will eventually cost someone to lose theirs, if not his own. Because of all the pain, sufferings, financial burdens, and overall creation of trauma and issues in the many lives he's affected, I petition that the court give Mr. Hensley the maximum sentence possible for his crimes, so that my family and others he's affected may know some semblance of peace. To Mr. Hensley, despite everything you've done to my family over this very long process and the disdain I have for you as a human being, I hope that your time behind bars will allow you to see life differently, and that you can truly find the error of your ways to become better for yourself and your family. So with that statement, I think we have 2 individuals that are reported by Mr. Stagel to have suffered emotionally from this, his 9-year-old daughter and his wife, both of them were in the crime time. I think that would validate more than 10 points.
I object to that.
Hold on. So, Mr. Hensley, what is your objection?
Tell him prove everything he's saying. If his wife and everybody went through the trauma, show me the doctor bill and report that he went through it. Because I can't believe somebody that would slam their brakes on the interstate at 75, 80 miles per hour deal with trauma. You could have killed us and everything behind me. Ain't no such thing as you got trauma for you slamming your brakes.
All right.
Prove the accusation that you made. Prove it.
All right. So, sir, I am going to
reading
grant.
the script like you coming from a movie or something.
I am going to grant the request for scoring OB4 based on the victim impact statement here. It does appear to meet the definition. Now, OB4, for the record, psychological injury to a victim could be scored 10 points if the serious psychological injury may require professional treatment, and in making the determination, the fact that the treatment has not been sought is not conclusive. First, we have the issue of the 9-year-old in the car, apparently with special needs, and dad, victim, has expressed in that statement that was just read into the record how this is still affecting the minor child. And that makes sense in court as it relates to somebody that's 9 years old and was observing somebody pull up next to them and point a handgun at them.
Still haven't been proven for the record.
Mr. Hensley, you've been convicted of that, sir, by the court.
We're going to have our
Okay.
We will have our
So please let me finish, and then I certainly will give you the opportunity to address the court before sentencing. And then also, pursuant to the statement that was just read into the record from the wife, who also was in the car, according to the testimony at the trial, she is not only suffering from the effects of this, has sought treatment and
This is where the tone in the courtroom noticeably shifts. Up until now, the judge has been patient, almost methodical, in documenting every opportunity this defendant was given to obtain counsel, request representation, or move the case forward. But now the court is done pretending this confusion is accidental. Judges are trained to spot patterns, and what's being laid out here is a clear timeline of delay, missed appearances, repeated refusals to answer direct questions, filings that don't apply to case, and last-minute objections that go nowhere. Courts don't punish people for self-representation, but they absolutely will not allow it to be used as a weapon against
the statement into the record, then nothing else from victims,
That's correct, Your Honor.
and then anything on behalf of then the people.
Your Honor, the recommendation on the 0 to 17 guideline range is 12 months on count 1 and 2, and 2 years on count 3 preceding the count 2 sentence. The people did initially support that, but with the change in the sentencing guideline range, obviously this does open up, Your Honor, to more opportunity for incarceration if you so choose, and we would leave that at discretion. But otherwise, we ask that you at least follow the recommendation as intended by Congress.
All right. So, Mr. Hensley, I'm going to give you the opportunity before I ask you to address the court for sentencing. Do you have any additions, corrections, or deletions as it relates to the pre-sentence report?
thing I can say.
Do you have any
All those
additions, corrections, or deletions?
All those accusations are false, and none of them have been proven.
Okay.
Not one. And he talking with this story.
As it relates to this report, do you have any
I don't have no
additions,
report.
corrections, or deletions? Excuse me.
No, I don't have the report.
All right. So, as it relates to sentencing, is there anything that you want to state to the court before a sentence is imposed?
You know, I have my medical information. You know, I have stage 3 cancer. You know, I have head trauma. You know, I have neck and back injury and something with a drop foot. For the record.
Anything else then,
That's
Mr.
it.
All right. So Mr. Hensley has provided, it is accurate, information regarding different medical issues that he is suffering and is suffering today, as a matter of fact. However, as the court sat through this trial, it's clear to the court that what Mr. Hensley was engaged in is troubling. The testimony of these victims where they were traveling on westbound I-96, minding their own business, when Mr. Hensley's vehicle comes up behind them, at a high rate of speed, the victim described with great clarity how close Mr. Hensley and his vehicle were to them, to the point they were extremely uncomfortable.
Objection.
Did not, hold on, Mr. Hensley, let the court finish, okay? To the point that they thought they were going to be struck. The victim, I recall, describing being unable to even see the front of Mr. Hensley's vehicle. That's how close it was, meaning the grill, headlights. I recall the testimony. And that they immediately got over. Victim then went on to describe that Mr. Henley pulled up next to them and pointed a handgun in this manner, of course, pointing over to the right and directly at these individuals. The victim described how he reached back, sort of to shield his family, and that they were getting down as best they could.
What's coming next is the emotional core of this entire case. Up until now, we've been hearing arguments, objections, and procedural maneuvering, but sentencing is where real harm finally takes center stage. Victim impact statements exist for one reason: to remind the court that crimes don't happen in a vacuum. They ripple outward, affecting families, children, finances, and mental health long after the incident ends. This isn't speculation, it's lived experience. When a firearm enters a situation involving innocent people on a highway, especially a child, the trauma doesn't disappear once the traffic clears. Judges weigh these statements heavily, not out of emotion, but because the law explicitly recognizes psychological injury as real harm.
Objection, man.
Mr. Hensley.
I drive a
Two
BMW.
objections.
Anybody with an autopilot vehicle, you know for a fact it won't do that.
Right.
That's a
So-
fact.
So Mr.
Not what
Hensley,
he giving you on out of his mouth. A fact. An automobile will not get up on nobody automatically with jam brakes. I told you
Trial.
BMW does that.
the trial is over. You had
Oh,
an
it's not over.
opportunity
It's not
to
over.
cross-examine those witnesses.
I did that, and you deleted everything I said.
Now, court
And
made
you heard
rulings.
everything that they said was a
So
lie.
now
And you know
you
it was
need
a
to
lie.
let the court finish, all right? So the testimony was as the court has described, and there is no doubt that all of those actions Mr. Hensley is responsible for. That's the ironic part of that. He creates a situation that causes discomfort for these drivers, and then he's the individual that introduces a gun to the situation. Court heard 404B evidence that was remarkably similar, where Mr. Hensley is right on the bumper of a young lady, Grand Rapids, Kent County area, and then when she is very uncomfortable and pulls over and stops, Mr. Hensley again introduces a gun, pointing it at that individual. Now, I mention this because I'm not using that as it relates to a sentencing issue. I'm using that, and that it's clear Mr. Hensley drives in a manner that endangers other people, that causes them to report his activity to other people, and then when they attempt to evade, if you will, what Mr. Hensley has caused, then he introduces a gun to the situation. Now, Mr. Hensley, I don't have to tell you that it's fairly obvious that in today's world, right, today's world of shall issue CPLs, that even if you believe that somehow you're justified in displaying a weapon, and for the record, there's nothing in this trial, nothing this court heard with the 404B evidence or the incident at hand here that we're sentencing you on that would suggest that in any way, shape, or form that you were not responsible, that you had any legal justification to introduce a weapon to it. But even assuming in your own mind that you were, what happens with that in today's world is they would have a very easy avenue to articulate, I felt in fear for my life or great bodily harm, and assuming they were lawfully carrying a gun, could take action, shoot you, in other words. And I can remember just in little Ione County, an incident that occurred just a few blocks from here, in which an individual was tailgating a lawful CPL holder.
This response of the defendant is one of the most revealing moments in the entire hearing. Instead of acknowledging fear, vulnerability, or responsibility, he attacks the credibility of the victims themselves. This is a classic minimization tactic, arguing that because someone didn't respond the right way, their trauma must not be real. Courts reject that logic outright. Trauma isn't measured by medical bills alone, and the law doesn't require victims to prove fear beyond common sense. A gun pointed at a family on the highway speaks for itself. What's especially damaging here is a complete lack of empathy displayed on the record. Judges take note of that.
The ironic thing is maybe it's the one time that a government program worked 100%, because to get a valid CPL, you have to take this course, do all those things, and part of that is shooting your gun 15 times or something, I can't remember.
I worked on my own car. I knew about a CPL.
Yeah, well, my point is, so they both hit their mark. and they're dead. And it's started from something just like this. And so my point in demonstrating the story to you, retelling the story, is when you engage in this kind of behavior, it puts your own life at risk. Put your own life at risk. And that you are lucky that hasn't occurred to you, but you certainly have frightened the heck out of people with what I heard in this trial. You certainly were in the wrong, and you're not a valid CPL holder. That's the other problem.
Because I don't need it.
All right. Well, I recognize you think that you have some fundamental rights that I'm not aware of found either in state or federal constitution, and you certainly can take those up on review, right?
I'm already in Western District Code already.
So that's fine.
Okay.
You can appeal anything that you'd like, any reason you think you have a valid appeal, but they're simply not found in state or federal constitution. And so here we are today. So that's how we end up with a carrying a concealed weapon, felonious assault, felony firearm. And what the court likes to do, Mr. Hensley, as I'm reviewing this, I will say this, I'm weighing positively in a positive manner here. You stand before the court at age 50, you don't have any prior criminal history.
Exactly.
Which is somewhat remarkable when I heard about the 404B evidence. So
exactly.
I don't know how that didn't result in some sort of crime, but it didn't. And I'm recognizing that, and I'm going to recognize that in the sentence I'm going to impose here in a minute. We do have the sentencing guideline now, which is 5 to 23 months. Court likes to think about the middle. The middle of 5 to 23 is going to be 14. And I also want to recognize that
this is where legal nuance becomes incredibly important. The judge isn't speculating or reacting emotionally. He's applying a sentencing guideline exactly as written. Psychological injury doesn't require a therapist's invoice to exist. The law explicitly states that the need for treatment can be inferred from circumstances, especially when children are involved. A 9-year-old with special needs witnessing a firearm pointed at their family meets that threshold without question. This adjustment isn't punitive. It's procedural. And once those points are added, the entire sentencing range shifts.
A reasonable doubt at trial. I recognize you disagree with that.
Because you had
asked the court to decide it,
photos,
and
you
the
had
court
video,
decided it.
you had somebody mouth.
Those are all evidentiary issues that you, again, can explore on appellate review, sir. You're welcome to do that.
Yes.
All right. So as it relates to the carrying a concealed weapon, all right, so carrying the concealed weapon is count or charge number 1. Court's going to impose a sentence of 12 months to 5 years. That's under the minimum guideline range of, or the middle, I should say, of what the court was looking at 14 months. So it'd be 1 year to 5 years with the Michigan Department of Corrections, and you do have credit now for 14 days that you have previously served. As it relates to the felonious assault, now this would be charge number 2. The court's going to impose a sentence of 1 year with the Michigan Department of Corrections to the statutory max of 4 years. You will receive credit for 14 days that you have previously served. And then as it relates to count 3, this is the felony firearm. The court is required, Mr. Hensley, to impose a sentence of 2 years with the Michigan Department of Corrections. And then counts 1 and 2 that I mentioned earlier will be served concurrently with each other, but this count 3 by statute is required to be served consecutive with and preceding these other 2 counts. So 2 years with the Michigan Department of Corrections. As it relates to the monetary obligations, Mr. Hensley, the court is required by statute to impose $130 as a crime victim rights assessment.
The judge's recollection of the trial is deliberate and precise, and that's no accident. Sentencing isn't about relitigating guilt, but the court is absolutely allowed to consider how the crime unfolded. Tailgating at high speeds, escalating aggression, and then introducing a firearm turned a traffic encounter into a life-threatening event. The most damning point here is causation. The judge makes it clear. This situation didn't happen randomly. It was created. And when a defendant attempts to blame technology, autopilot systems, or external factors, the court shuts that down immediately. Responsibility doesn't disappear because someone claims automation. This case is a textbook example of how courtroom behavior can directly influence outcomes. The judge didn't rush this process. He documented it. Every opportunity for counsel, every warning, every explanation was placed on the record. When sentencing finally moved forward, it wasn't driven by emotion or impatience. It was driven by facts, guidelines, and the undeniable impact on innocent victims. The takeaway here is simple but powerful. Accountability isn't optional, and courtroom theatrics don't outweigh real harm. Judges will protect the defendant's rights, but they will not allow those rights to be used as tools for delay or denial.